the Scrivener by Herman Melville. And I see all of you have your names in, so let's begin. Can you turn the volume up? Okay. Okay, 11 of you did get it correct. Go to the next. Okay, go ahead. Next. That tells me how far along some of you read. Go ahead, next. This is a quick one. See how it's... Okay, go next. What happens to Bartleby at the end of the story? Oh, everyone got that answer. Okay, next. And the last one. Okay. All right, let's open up our iPads to the classroom website. And what we're going to do today is we're going to develop an argument either for or against the lawyer. Did he have responsibility to take care of Bartleby? Did he have a moral responsibility? Maybe a religious responsibility? Maybe did he have a legal responsibility? And I want to ask you this question. If you were to see somebody, let's say, by a railroad track and you were walking and a lady trips and she falls and hits her head, she's unconscious on the railroad track, and you know a train's coming. You're the only person around. Do you have a responsibility to remove her from that track? You're not going to get hurt. The train's off a distance. Do you have a responsibility to do that? Okay, so when we read literature, literature should come alive to us, and we should, at that point, say, why is it important that I learn this? How can this apply to life? So we're going to take a look at the legal stance of the lawyer, whether or not he was responsible to take care of Bartleby, and we're going to find evidence in the text to argue both sides. If you go under the tab on the website, The Gifted and Talented, let's go to Document 1 and open up Document 1. What we're going to do in this class is we are going to have a court hearing. A court hearing is a gathering within a courtroom that is called for the purpose of conducting some type of legal procedure. There are many kinds of hearings. Some of them involve civil court issues. Others involve criminal court issues. The structure and the focus of a hearing may be different from one location to another. Many countries, it's called an arraignment, and you've probably heard of arraignments. So we're going to have an arraignment to find out if there is enough evidence to hold a trial. Is there enough evidence to keep the arrest and to hold a trial? So we're going to have an arraignment, a hearing, and we're going to find out if there's enough evidence to charge the lawyer, in this case, with a crime concerning the death of Bartleby. So let's go back now to our next document, document number 2. I made that up to make it look like a legal document. This legal document will be the students of the advanced placement class, that's you, versus the employer of Bartleby, the Scrivener. He will be the defendant. If you look at this legal document, the introduction is going to give you a summary of what happened. These are called stipulated facts. In other words, they're not debated. Both sides agree to this. So could I have somebody read that? Somebody want to read those stipulated facts for the class? Somebody? Okay, go ahead.
The defendant has a law business that employs Scriveners. Bartleby is one of 4 employees. Additionally, Bartleby produces a highly acceptable quality of work. But as time proceeds, his willingness to work decreases. He responds with the phrase, "I prefer not to," when asked to perform tasks. The employer makes several futile attempts to reason with him. At one point, the employer comes to learn that Bartleby is leaving the office. Eventually, Bartleby refuses to do any work at all. In addition, he refuses to leave the office. The defendant requests Bartleby to leave, but eventually is unable to evict him. Therefore, the defendant moves his business. The new tenant requests assistance from the defendant to remove Bartleby from the residence. After several attempts, including an offer to live with him, on which Bartleby refuses, the defendant relinquishes his responsibility. Bartleby is taken into custody and incarcerated. The defendant visits him and hires the cook to provide food for Bartleby. Bartleby expresses his disheartenment for the rejection. Eventually, the defendant, who arrives for a visit, finds Bartleby deceased, cause of death, starvation.
Okay. The hearing that we're going to conduct, and you're going to be the attorneys. We're going to have some of you as the attorneys for the defendant, for the lawyer. Some are going to be attorneys for the plaintiff, which will be us as the class, and then we're going to have some of you sit in as a jury. Okay, let's take a look at the law. The law, it says this hearing is going to be bifurcated. So what that means is there's going to be a burden on both sides. In other words, those that are on the defense have to prove something, and those that are on the plaintiff have to prove something. Sometimes it's only on one side, but in this case, both of you have to prove something. Okay? The plaintiff will have the burden to prove that the defendant was guilty of contributory negligence that resulted in the death of Bartleby, and the defendant will have the burden to prove that his actions were enacted to provide the safety to Bartleby. And if you look below, this is an actual law in Ohio. It's called contributory negligence. And I put the law there. I want you to read through that because that applies to you too. Do you have an obligation if, for example, somebody falls and you know they're going to be in danger, on a railroad track or somewhere? Do you have an obligation by law to help them? Now, we know that if you help somebody, for example, if you give CPR to someone and you're not certified, you save their life, but you break maybe their ribs. That's where we have the Good Samaritan law that can be argued in your case to defend you, that you were saving their life, although it protects you from things like that. Because before, people wouldn't want to even help because they were afraid of being sued. Now we have that law, which is a Good Samaritan law, that helps to protect you. In this case, this code, the Ohio Revised Code for contributory negligence, according to this, you're required to provide safety to someone. And if you don't, you can be charged with contributory negligence. And I want you to be able to read through that. The jury will hear both arguments and render a decision. The judge, and I'm going to be the judge in this case, will consider the jury's decision and conclude judgment. So, let's go back. And these will be available for you. But let's go back to, you see on the main page, we see document 3, which is the defense's instruction. Let's go ahead and just pull that one up. It's the same, very, very similar to the plaintiff. The defense is going to have a minimum, and the plaintiff also, of 4 student attorneys. You can have more if you'd like, but you have to have at least 4. You're going to prepare a written speech. Each attorney has to prepare just a short little, like 2-minute written speech. You're going to research information. You can have other students in your group that can provide visuals, such as a photograph or map. You can enlarge it, whatever you might want to do. But you need, as a team, as a group, to convince the jury that, for example, if you're on the plaintiff, that the lawyer was guilty. It was his actions. He didn't do everything he could because of the mental state of Bartleby. He could have kept him from dying, and he didn't. That he, by law, is in violation of this code, and he contributed to the negligence that resulted in the death of Bartleby. The defense is going to argue that he did everything in his known ability to provide safety for Bartleby. Okay? I give you an example. You're going to have your first attorney, so let's use one as an example. If you're attorney one, you're going to give the opening statement, and I actually give you some wording there, but you'll have to provide information. You'll say something like this: if it pleases this honorable court and jury, and then you're going to provide a timeline of what happened. Okay? And today we are going to prove that, and you're going to state your argument. And then you might say something like this: the lawyer provided time and time again not only concern but care for his employee in this case. We will provide evidence that our client clearly made all reasonable efforts to care for Bartleby, thus holding that his actions were enacted to provide safety. And then you'll have your second attorney come up, and they're going to have one argument. They're going to have one point. They're going to try to prove, in this case, this is what he did. He did this particular act to provide safety. You know, he, for example, you might say that he provided money for him to have food or whatever, to buy food. And you'll have to refer to the text where that happened. So you're going to give textual support to back up what you say, and then the next attorney will come up and they'll find something different, and they're going to make a point, and you're going to bring out all your points. After the defenses, they rest, then we're going to hear the plaintiff's side, and the plaintiff will do the same thing. So if you go back and you look to the plaintiff's instruction form, you'll see that it's very similar to the defense. They'll have to have 4 attorneys, and I go through this motion. And then let's open document 5, and you will see the jury's responsibility. And the jury's going to listen. Each juror on that jury is going to take notes. And you're going to have to write up just a paragraph. And I give a sample there. If you look down there, the jury member number 1, the first paragraph will say this: recommendation for the defense concludes that, and you're going to say whether you agree or disagree, that they met the burden or not, and was guilty of contributory negligence that resulted in the death of Bartleby, and why you feel that way. Why you feel that way. And then the second paragraph, you're going to give your recommendation concerning the case, if you felt the plaintiff met their need or not. So each juror is going to have one paragraph that they'll be writing. So you need to take notes on every single thing that's discussed and say, you agree with that or you don't, and why. Okay? At the end, you're going to give me a collaborative paper. This will count for your paper in this class. The defense altogether will combine all of your questioning, attorney 1's questioning, attorney 2's questioning. They're going to get it all together in one paper, submit that for a grade. The jury will have everybody's testimony put together in one paper, submit it for a grade, and so the plaintiff will do the same. All the directions are here. So what I'd like to do now is to break you up into groups. And at that time, you can work in your group. You can read through the directions, and if you have any questions, we'll work on that, and we're going to hear your case tomorrow. We're going to hear you argue your case tomorrow. Right now, we'll work in groups. So we're going to have the defense sitting right here. We're going to have the plaintiff sitting over here, and we're going to have the jury sitting here. And you can read through your instructions yourself. So I'm going to say just through defense, plaintiff, jury. 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 And defense. Okay? Defense over here. Defense over here. Plaintiff over here.
Good afternoon, Your Honor, and members of the jury. I would like to make you aware of the time that my client found out Bartleby was in prison. He rushed down to talk to me. He personally paid, out of his own money, not his office's money, the grub man to keep an eye on him, care for it, and to personally look out for Bartleby and make sure that he gets the best attention and care. The following is an exact quote that can be found on page 51 of what the narrator asked of the grub man. I want you to give particular attention to my friends there. Let him have the best dinner you can get, and you must be as polite to him as possible. It is clear that my client wanted the best care given.
Okay, when he first recognized that Bartleby was living there by himself, and he said such great loneliness, and he had this like a fraternity with him, this bond with him. He says the bond of Adam with him, that he is a human being. He's a human being. I may not like him as an employee, whatever. He represents humanity. And when you see somebody like Bartleby, who, whether he was offered every means to be helped, or whether he was, negated any help, and neglected that help, whatever it is, he still represents humanity. And we should stand back, and when one person dies, out of neglect, that's happening all the time. So I think Melville at this point is trying to point out to us the very thing that this Ohio Revised Code that came into play recently, 2008, I believe it was. He thought about this back in the 1800s, that we have a responsibility. We have a responsibility because we have this kindred with other human beings, no matter who they are. We may not like them. They may be different than us. They may do things strange, but we have a responsibility. And whether he held up his responsibility or he didn't, that's up for the jury to say, right? Okay, so we'll find out tomorrow. Okay. Oh, yeah, go right ahead.
Well, it was the narrator's choice to point out that he was deranged, so if he felt that it was okay to point out his flaw, I understand he went out of his way to give him care such as shelter and food and stuff, but he didn't try to give him the necessary care such as hospital or medication that would bring him back to his regular mentality.
Okay. So he would go so far, but not far enough, is what you're saying. Yeah. Okay, yes.
As well as what Bartleby was saying, that as he was looking at the wall, that was his feeling of coping, stuff like that. The definition of insanity range also includes depression, anxiety, those other smaller but can lead to bigger things.
Okay, so that can also be a sign of that too. Although that may be what some people like, to be alone and just look. It's also a sign that could be a problem. That's a good point. Yes.
Someone who only knows someone so much can only do so much to help them. And I feel like if he would have taken him to a mental hospital, there are regulations that mental hospitals have, you have to give information. But if he would fail to provide that information about Bartleby, they wouldn't be able to accept him because you have to have legal records and such to be admitted into a hospital and insurance and birth certificates, etc. But if if my client was unable to provide any of that information, even if he tried, he would most likely be neglected of that.
Okay. Another really good point that we might want to bring out is that attorney is not equipped to diagnose whether there's mental illness or not. He's not skilled to do that. But they would come back with he didn't seek out that skill for him he didn't take him to get diagnosed and get help. Okay? Yes.
Isn't it possible if he would have attempted to bring him to a hospital,
that they could have treated him until he was brought back to his proper mindset and could fill out the rest of his paperwork. Because there's been cases of people who have been in almost accidents where they forget everything and they have to be put in mental hospitals. Who knows that they have records? They may not know who their family is, nobody can know who they are, but they still get treated. Why Bartleby don't?
Also, the homeless that we see on the street. Good point. Very good point. Yes.
If he couldn't prove or give him proper help that he was deranged, then why would he feel that it was important to state it?
Oh, so why would he have said it? Good point. Very good point. Yes.
It's like the fact that he even recognized that he was deranged as stated in the text would lead to the point where he should have made even an attempt.
That's exactly what Janae is saying. Yes. Right.
If it didn't work, then oh well, you could say like
Right. If he had taken him to the facility and they would have said he's mentally competent, then he would have not been held in negligence. But because he didn't, is what you're saying.